to begin by reading out a statement. The hearing on this application is being held by way of video conference. Any orders or directions made after or during the course of this application will be issued by the Registry in Dubai on Justice Lord Angus Glennie's instructions. We are here for a hearing in the matter of CFI 093-2020 before Justice Lord Angus Glennie. The claimant is represented by Pencil Masons LLP. Lead counsel is Matthew Watson. The first defendant is represented by Allen & Associates. Lead counsel is Nicholas C. The second defendant is represented by Curtis Mallet Pro Colton Hosel LLP. Lead counsel is Antonia Burt.
Thank you very much. Mr. Watson, obviously it's your application. You can take it that I've read the affidavits and the skeleton arguments and obviously the request. So take it that much has been read and make your submissions accordingly.
I'm grateful, Your Honour. That might short circuit quite a bit. In terms of bundle references, I assume Your Honour is working from case lines, the virtual bundle. I intend to just give page reference numbers.
Right.
I don't know if how familiar Your Honour is with this system, but there is a find tab and a find the page tab, so that if I were to say, for example, page 12, which is the start of Malone and Friends defence, you could just type 12 and get there immediately.
It's easier if you tell me what the document is and the page number, because my index down the side gives me access to all the exhibits documents.
In which case, I'll do it that way, Your Honour. I in fact have a hard copy bundle because I'm old-fashioned like that. But between us, hopefully we'll get there. As Your Honour will have seen, this is an application for an order under RDC 19.1 to compel the defendant, Kent College, to answer an RFI. There are 32 requests, and I'm going to take some of those in groups. They are all opposed. Although I am the claimant, I'm really in the position of a defendant today, because as Your Honour will have seen from the skeleton arguments, Infracare's claim is in debt for unpaid invoices for provision of maintenance services. And the defence is twofold. Firstly, that as a result of breaches of that contract, the defendant's obligation to Kent College's obligation to perform has been no longer arises, put it that way. It's a provision of the UAE Civil Code, but we don't need to get into that today. And the second defence is a defence of set-off. And so Kent College says that damages have arisen from breach of contract and from tortious liability, and they seek to set that off. Effectively, the same torts are alleged against Chicago, and that's why you might have seen it being said that there's a degree of overlap between the requests that I make and the requests that Chicago has. Just so Your Honour is familiar with the structure of how the maintenance services agreement and the novation work, it's accepted by Infracare that as a result of the novation, Infracare is liable for breaches of contract that Chicago committed whilst it was the party performing the maintenance agreement. That was the effect of the novation. So prior breaches of contract by Chicago, Infracare, we accept, is liable. Infracare is obviously not liable for Chicago's torts. Indeed, that's why a separate tortious claim is brought by Kent College against Chicago. I'm not going to say very much about the law, Your Honour. I don't think that there really is any dispute of principle between my learned friend and I, apart from in relation to what I term the fraud claims, and I'll address those as I'm dealing with that part of the request. But it's RDC 19.1. It's basically the same as CPR Part 18, with which Your Honour is familiar. My learned friends referred to the overriding objective. It obviously applies when assessing what's reasonably necessary and proportionate. Just very briefly, by way of outline, my submission, the test of reasonable necessity and of proportionateness, are satisfied here in respect of each of the requests for these broad reasons. In respect of whether the requests are reasonably necessary, as I will endeavour to show Your Honour, Kent College's counterclaim is vague. The result of that is that Infracare doesn't know the case it has to meet. And as I will show you, it's vague in a way which even prevents Infracare from properly preparing its own case. That's the first reason why it's necessary. The second reason why it's necessary is that, as Your Honour is perfectly familiar, the function of pleadings is to confine the scope of the case, so that by the time that we get to trial, everybody knows precisely what is in issue and what the court needs to determine. You will see, Your Honour, that Kent College has already, when we come to the fraud case, tried to put a gloss on what its pleading is. And these proceedings are going to be more expensive and more time consuming if the proper ambit of Kent College's case isn't defined now. These requests are all proportionate for essentially two reasons. It is said that I am asking for documents or evidence. Just to make it perfectly clear, I'm not. I don't expect in response to this RFI to get documents or evidence. I'm asking for two things. Firstly, clarification of the scope of the case, and secondly, particulars. Now, clarification is easy to provide because one simply states what the scope of the case is. It's easy to provide, and it's right that it's provided so that it's clear what is in issue. Where I'm asking for particulars, the information that is being sought ought to be information which is readily available. And if it's not readily available, that's particularly concerning where allegations of dishonesty are being made. So what I'm going to do, Your Honour, is address each of the requests now in the order in which they appeared in my skeleton, which broadly follows the order in which the relevant issues arise in the defence, although there will be a little bit of jumping around for which I apologise in advance. If I could ask Your Honour to take up my learned friend's defence counterclaim and additional claim. It starts at page 12 of the bundle.
Yeah.
And if Your Honour turns over to the first substantive page, it's page 13, paragraph 1.
Yeah.
The first and second requests both deal with a very small issue that hopefully I can deal with quite quickly. The end of paragraph 1, you'll see there's an allegation Kent College avers that both Chicago LLC and Infracare are part of the Varkey group of companies. And it's the allegation, the Varkey group of companies, which is the subject of the request. And if Your Honour moves through the pleading to page 17 in the bundle, paragraph 15.
Yeah.
You will see there's an admission of paragraph 3 of the particulars, and there's an allegation at the end of that paragraph, Chicago LLC, which is an affiliate of the claimant. And that allegation that my client and Chicago are affiliates appears quite frequently throughout the defence. I can deal with this one hopefully relatively quickly. Affiliate is obviously vague. It doesn't describe any particular legal relationship. We asked for clarification to understand precisely what was being alleged. It was refused. That's a concern in the context of fraud claims, as I'll show Your Honour, where what is being alleged is that Infracare and Chicago conspired together to do various things. In those circumstances, it's all the more important to know what the defendant means by affiliate if that allegation is going to be deployed in some way as part of the case on fraud. Now, Kent College finally said in its evidence, and this is certainly how I read the evidence, that all that is being alleged is that Chicago and Infracare have common shareholders. Now, if that is the extent of the allegation, so as if one deleted affiliate and just said Chicago and Infracare have common shareholders, if that is all that is alleged, then that is a perfectly proper answer to a request for further information. I would be perfectly content with that. It's important that that is done by way of an RFI, because as Your Honour knows, an RFI is a statement of case, and therefore it pins down the case.
You can take it. I understand that point.
Yes, so there are times, Your Honour, where I will endeavour not to teach Your Honour to suck eggs. The exuberance of young advocates. So
you can take it that I've read your explanation of all the requests and why you say they're justified.
Thank you, Your Honour. In which case, I'll take it relatively quickly then. That then is the first couple of requests. The third request relates to paragraph 27, which appears on page 24 of the pleading.
Yeah. Yeah.
And there is an allegation that the air conditioning was not functioning properly. And you'll see it leads into the allegation at the next paragraph, paragraph 28, where it's alleged that despite Infracare being notified, no measures were taken in order to maintain and ensure proper functioning of the HVAC system as required by the maintenance agreement. There's an allegation that the air conditioning is not functioning properly. Now, I'll just show Your Honour, if Your Honour moves to paragraph 51, which is at page 30.
Yeah, this is the list of things.
This is the list of particulars.
Yeah.
And one might say that they are somewhat vague, but I am, for the purposes of these proceedings, content to accept them. There are a list of some 17, because it goes over the page, precise mechanical problems and defects that are alleged. Now, it would be the easiest thing in the world for my learned friend to say, in response to my RFI in relation to paragraph 27, what the meaning of was not functioning properly was to say that it's encapsulated by the particulars at paragraph 51. The fact that Kent College won't do that makes me quite nervous about what allegations I might face at trial about technical faults that aren't pleaded here. And you'll have seen, Your Honour, that the answer that's given to this is, well, we've served 2 expert reports. But that's obviously not satisfactory for the reasons that I set out in my particulars. There's a practical problem about how, Your Honour, the court and Infracare goes through these lengthy, I don't know if Your Honour's had a look at those.
The reports, though.
Might be worth just turning them up very briefly.
I doubt it, but you can if you like.
Well, Your Honour,
to be candid, I know the sort of reports that are often referred to. They contain rather amorphous points, and what you want to do is to even if they do it by reference to the report, you want reference to particular paragraphs and so on.
It's not just particular paragraphs, but it's the precise allegation in the pleading verified by a statement of truth, so that one, I can plead to it, and two, it's clear and in one document. And the rules, Your Honour, as I pointed out in my skeleton, make it quite clear that one shouldn't plead by way of attaching an expert report. And it's important as well in the context of this particular jurisdiction that the second expert report that's relied upon is a report prepared by an officer of the local Dubai courts to whom Kent College went before these proceedings commenced. That is a court that has no jurisdiction over this dispute. The findings of an expert appointed by a, for this purpose, foreign court have no weight whatsoever in the DIFC. There's not even a report that the court, in my submission, could give permission for the other side to rely upon. Because
why not?
Well, because a judicially appointed expert of the local courts would have to appear in the DIFC courts as an expert witness, make the relevant declaration, appear in person if necessary, so that he can be cross-examined on the findings of his report. My understanding is that officials of the local court wouldn't countenance being summoned I don't mean in the formal sense, but appearing as a witness. Now, maybe my learned friend is going to call.
You may be right about that. You may be right about that, but there's no rule of the DIFC that evidence would be incompetent if it was led.
No, if it was led, I think my submission is I would be very surprised if that evidence were led.
Yeah.
If the learned friend was going to call the judicial officer as an independent part 31 in this jurisdiction expert. But I think Your Honour has my submissions about the pleading issue. And so I shall move on and deal with the next two requests, which relate to something called the defects liability period. And if Your Honour could turn to page 25 of the defence, paragraph 32. This paragraph 32 is a composite paragraph, and that it makes two quite distinct allegations. And the first half of this deal with the issue of the defects liability period. And you'll see there's a first phrase that ends about 3 lines down to King's College's attention. And then it reads, it was also the claimant and or Chicago LLC's duty to take appropriate corrective measures, including advising upon, managing, implementing and or procuring any necessary corrective action from an appropriately qualified source, prime among which the additional defendant, that's Chicago, while such defects were still covered by the defects liability period. So what is being alleged is that there is a period called the defects liability period under which Infracare and Chicago before it was subject to some duty arising out of the maintenance agreement. That's what's being alleged. And the request is simply to know what is the period that Kent College allege is the defects liability period. When does it start? When does it end? So that I know the scope of this duty. The answer that comes back from Kent College is simply that because Infracare was a party to the maintenance agreement, it must know what the period refers to. But I won't take Your Honour to it. We can do if necessary. There's nothing in the maintenance agreement that says when the defects liability period begins or ends. The only reference to it is a single sentence, and that just refers to DLP. DLP is the only reference to defects liability period in the entire maintenance agreement. But the answer isn't satisfactory, because what it does is it dodges the issue. And the issue isn't what do I think the defects liability period is. The issue is what does Kent College allege is the defects liability period? What's the scope of their case? Infracare might agree with it, it might not. That would help to elucidate the issues that the court has got to deal with. But as it stands at the moment, both the court and Infracare have no idea what period this defects liability period is said to relate to, and therefore the scope of the duties. Your Honour will see when I come back to deal with this, what I call the second fraud, that this reference to the defects liability period crops up again and again and again, and so you'll see why it's important to know what this period is. But I've made that submission. I will deal now with the first fraud, and here I may need to get into a little bit of the detail about the UAE Civil Code. But what I plan to do is take you to the pleading, my problems with it, and then deal with what my learned friend says about it in his skeleton argument. And this encompasses requests 6, 7, 8, 9, 10, 11, 12, 13, 29, 30, 31, and 32, because there's a lot of different parts of these pleadings about which one would want to know things in order to make a case of fraud. As I understand it, the case starts from the second half of paragraph 32, which Your Honour should have in front of you.
Yeah.
And the allegation is that Kent College further avers that the advance payment and performance bonds under the construction contract were only released as a result of assurances given verbally and or in, I assume that is supposed to say writing, by the claimant and Chicago that Chicago LLC would pay in full its MEP subcontractor PowerPoint and ensure that PowerPoint rectified and construction defects and complete satisfactory construction, testing and commissioning of the school system. And then there's reference to an email dated 15th of October 2018 sent by the CEO of Chicago. Nothing alleged to have been sent by Infracare. The problem with this paragraph is that there's some statements are alleged to have been made, namely that Chicago would pay PowerPoint and would ensure that PowerPoint rectified construction defects. Sorry, Honor, all the screen just moved, but I think it's fine. But what is missing are any of the particulars that you would ordinarily expect to see, either of a written assurance that is relevant to Infracare, and one of the requests specifically asked, well, you've referred to email correspondence with Chicago, but do you allege that there's any written assurances by Infracare? Refused to answer. But insofar as allegations are being made of verbal assurances, and it was said quite clearly in Malone & Friends evidence that served in response to this, that they do rely on oral discussions, there's no allegation of who said anything, what was said, or when it was said. And so I'm in a position where how do I even begin to investigate this allegation? Because I've got 650 employees who moved to Infracare from Chicago. Who do I have my instructing solicitors go and take a proof of evidence from? Just the basic matters, even before we get to doing disclosure and exercises like that. To develop a bit further, if you want to move to paragraph 40 of the defence, which is at page 27.
Mm-hmm.
It says there's been some plea about the reports that I've mentioned to you, Honour. Paragraph 40, against this background and further to verbal and or written assurances given by the claimant and or Chicago LLC as pleaded above. And there's a lot of this, you'll notice, Your Honour, and or, which is not entirely satisfactory in the context of a fraud claim, because they ought to be able to say whether of any particular incident it is alleged against both of us, i.e. some employee who worked for both of us, or there was an employee for one and an employee for other who both made the same statement, or whether it's either of us. But saying and or it dodges the need to plead with particularity.
Yeah.
One of the requests related to clarifying precisely again what the verbal or written assurances meant. Did they mean the ones that are being obliquely referred to in paragraph 32, or do they mean others? Again, Kent College won't say. You get again the repeat of the release of the performance bond under the construction contract, in the belief that the monies thus released would be paid to PowerPoint in order for the school's BMS and HVAC to finally be made operational. And this is a crucial part, Your Honour. However, the claimant and or Chicago LLC deceived the defendant, Kent College, in this respect, and in fact failed to pay to Chicago LLC's MEP subcontractor PowerPoint any of the monies paid. Now, that word, deceived, is pretty clear. That is an allegation of dishonesty. There's no escaping that, for my learned friend. If you use the word deceit or deceiving in a pleading, that is an allegation of fraud. And it's clear that what is being alleged is a fraud. If I can ask Your Honour to turn to page 33 of the pleading.
Mm-hmm.
These are the list of particulars in relation to the tort claim. So perhaps if you want to just orientate yourself, the prior 2 pages had that long list of particulars which were the breaches of contract. This is the tort claim. Further alternatively, this is at paragraph 53, the claimant engaged in acts causing harm to the defendant, Kent College, contrary to Article 282 of the UAE Civil Code, and those acts included acts of deception, contrary to Article 285, and to come back to the significance of Article 285, because in my submission it's very significant. And then there's a general plea that the claimant, whether acting alone or in combination with Chicago, that's the veiled allegation of conspiracy, which makes it important to know what relationship they're alleging between us, unlawfully caused Kent College harm and or deceived Kent College, thereby causing harm as follows. And you've got particulars of deception, and the first two we'll come back to because they're in fact the second fraud. But the final three subparagraphs, paragraphs 3, 4, and 5, all relate to this issue of the performance bond and what had been said about what PowerPoint was going to do. And each one starts by deceiving Kent College, by deceiving Kent College. So again, it is quite clear that what is being alleged is some sort of deception. And what is missing, or any in this entire pleading in relation to this allegation, is any of the essential elements of a plea in fraud. That is, what was said, who said it and when, that what they said was false, and that there are facts, and what those facts are, from which the court can infer that the person who made the statement knew what they said was false. I mean, I don't think we need to go to Lord Millett's quite famous dictum. But the point about an allegation of fraud, as I'm sure, as I know you will be aware, is there need to be a plea of some facts as to the mens rea, as to the mental element, as to the actual dishonesty, some facts that the court can infer the dishonesty from, and that's completely missing. So at the moment, how could we possibly have a trial of this issue? Certainly not fairly, because at the moment, Infracare has just no idea what evidence or what allegations is going to be led, what allegations are going to be made, what evidence might be led or need to be led, therefore, about an allegation of a quite serious allegation of fraud. Now, my learned friend in his skeleton says that he's not in fact alleging fraud, and he makes 2 points, and I'll deal with them briefly. The first is he says that RDC 17.43, which requires full and specific details of any allegation of fraud, dishonesty, malice, or illegality, he says that that just applies to common law claims. In my submission, that is wrong. There's nothing in the language of the rule that limits its scope to only common law causes of action. And it would be odd, particularly in an international court such as this, for the application of a general rule about pleadings to turn on the governing law of the particular cause of action. In fact, in my submission, 17.43 is dealing with the nature of the allegation, whatever the substantive cause of action is. Mm-hmm. The question is, what cause of action are you alleging? It's, are you alleging some sort of fraud, dishonesty, malice, or illegality? And if you are, you've got to provide the particulars. Mm. The second answer that my learned friend tries to give is he says that, well, actually Kent College isn't alleging dishonesty. He says, in fact, he's just relying on Article 282 of the UAE Civil Code. That's acts causing harm, and that all he needs to do is to show that there was an act. And
what article was that?
Article 282.
Yeah. Yeah.
Now, the article that my learned friend didn't set out in his skeleton was Article 285, and it's quite plain that he relies on it because, as Your Honour saw from paragraph 53 of the defence, mm-hmm. It is alleged that we engaged in acts causing harm, and those acts included acts of deception contrary to Article 285 of the UAE Civil Code. Now, I just want to take Your Honour to Article 285, It should be the very last document in your bundle. It was an addition.
I don't think I have that.
It should be at page 957 of the bundle.
All right. 9.5. Okay, I've got it. Yep.
So this is an extract from Whelan's commentary on the UAE Civil Code, and you can see Article 285 in the middle of the page.
Yep.
If a person deceives another, he shall be liable to make good the harm resulting from that deception.
Yeah.
And there's some commentary beneath it, and you'll see there's a little heading, historical reference given from the Hadith. The word ha, as to the subject matter, is used by the jurists in the meaning of making somebody accept what is no good by lying and misleading means, inducing him to proceed in a circumstance where if he had known the truth, he would not have proceeded. You'll see that there's various further references to deceiving, false lying. It is unambiguous, Your Honour, that an allegation of deception under Article 285 is an allegation of fraud. My learned friend can't say, well, because I bring non-fraud claims alongside fraud claims, I don't need to give full particulars of my fraud claim. If you make an allegation of fraud, you've got, or of dishonesty, you've got to plead it properly. If my learned friend is in fact saying that he no longer wishes to advance a case of fraud, then swathes of this pleading need to be withdrawn, and I might go so far as to say it was improper. I
wouldn't worry about improper or not. Let's just stick to where we are.
Yes, Your Honour. The third point that I would make about this, and I'll make the submission briefly, and we can go into it in more detail if necessary. But my learned friend rightly sets out in his skeleton the scope of Article 282. And Article 282, the boundaries between the acts for which somebody can be liable are delineated essentially by causation.
Yeah.
So, as Your Honour may have picked up from my learned friend's submissions, if the harm is direct, and the example that's given in the extract from my learned friend cites is a person directly breaking a pot, then liability arises. If harm is indirect, then in order for there to be liability, one doesn't just need an act causing harm, one needs intention or wrongdoing. Now, my learned friend in his pleading hasn't said whether he relies on the direct causation aspect of that or the indirect aspect, in which case he would also need to satisfy intention or wrongdoing. In my submission, it's pretty clear that he must be relying on the latter, not least because there's the plea of intention or wrongdoing. He pleads wrongdoing. And secondly, if Your Honour just stands back and thinks about the nature of the allegations, what is being alleged is that something was said, and as a result of that, various other things happened, and work ultimately wasn't done, and a performance bond was released. That's what's being alleged. In my submission, that's a pretty clear case of indirect harm. So,
surely I don't need to resolve this, because if an allegation of dishonesty is being made, it ought to be. You say it ought to be particularized. If it's said not to be necessary, well, then they can drop it.
Well, quite. I mean, if my learned friend wants to make clear in an answer to the RFI or by amendment that he only relies on Article 282 and only on direct causation, then that ought to be made clear, and that would, in my submission, narrow the case very significantly. But that needs to be made clear. If he's relying on indirect causation and therefore intention and wrongdoing, and therefore, he needs to rely on his allegations of, he wants to maintain his allegations of wrongdoing. It's a separate point, Your Honour, from Article 285, because Article 285 is a separate species of tort. So in my submission, he's trying to bring the wrongdoing in at two levels, both in relation to Article 285, but also to solve the causation problem in relation to Article 282. But Your Honour has the basic point. If he alleges dishonesty, he needs to particularise it, or Kent College needs to particularise it.
Mm-hmm.
I'll try and deal with the balance of the requests now, rather briefly. If Your Honour would turn to page 28 in the defence. Paragraph 44.
Yeah.
This part of the pleading starts what I've labelled the second fraud, and it starts to date and long after the alleged expiry of the DLP. There's the reference to the DLP again. This is where the DLP starts to become significant. It's alleged the defendant continues to discover system functioning problems. And then at paragraph 45, it said, in particular, the defendant has become aware of a snagging list on which the DLP monitoring was based. And the claimant believed previously that had been produced by its project manager, but now thinks it was prepared by Chicago. We've asked, one of the requests is precisely give us the particulars of the document you're actually referring to here, because they just refer obliquely to a document and then define it as the CMC snagging list. There's no plea, for instance, that on a particular date, a particular document was sent by somebody at Chicago or Infracare to Kent College, and things were said about that document. Paragraph 46, this is really where the fraud is alleged. It said the Chicago snagging list omitted a series of defects, doesn't say what those defects are, which were apparent to Chicago as early as 2017. So there's a plea of knowledge, but no particulars supporting the plea of knowledge, but which were concealed. And as a matter of ordinary language, concealment is an act of deliberate dishonesty.
Mm-hmm.
Concealed from Kent College's knowledge by Chicago LLPs and or the claimant's acts of deception, and have only recently to the defendant's knowledge. And then there's a reference to a later different truncated and incomplete snagging list. And I have to say it's never been quite clear whether what's being alleged is that there are two inaccurate lists or one inaccurate list, and this is just simply a second reference to it. But that's a matter that they could clear up by answering our RFIs. And you'll see the paragraph continues. The later inaccurate and incomplete snagging list was the list used by the claimant and or Chicago LLP in its exchanges with Kent College. Well, what exchanges? And was one of the means by which the claimant and or Chicago LLP concealed defects from Kent College. So it's not even quite clear whether this is the only act of concealment or deception that is being relied on, or simply one of others that are not pleaded. And again, clarification was sought, has not been provided. So there's no plea as to the specific defects that are alleged to have been deliberately omitted. No identification of the individuals responsible, who used these lists, how they were deployed, or any of the critical facts that would allow the court to infer that somebody deliberately knew about a defect and didn't draw it to anyone's attention as Kent College say they ought to. They must know the answer to these questions, they just won't tell us. If Your Honour turns now, just to pick up the last of the requests, to paragraph 51, that long list of particulars.
Yep.
And I'd ask Your Honour to turn to subparagraph 18, which is actually on page 31.
Yep.
There's an allegation that that Infracare failed to discharge its contractual duty of good faith. As Your Honour may be aware, there's an implied obligation of good faith in all UAE law contracts. So it's alleged that we acted in bad faith by concealing or participating with Chicago in the concealment of other issues affecting the school's main plant and machinery. Now, a very straightforward request in the RFI was made to clarify, is this a reference to the second fraud? Is this a reference to those particulars or those allegations I took you to earlier about concealing defects? Answer, won't tell you. That's what came back from Kent College, and they still won't tell us. So that's another part of the pleading that's just completely ambiguous about what is actually being alleged. And it would be the simplest thing in the world for my learned friend to say, this allegation of concealment is just a summary of the prior paragraph that we've been referring to. But the fact that they won't, again, is what causes the concern that has generated this application. If Your Honour looks at subparagraph 19, just over the page, in the premises, and for the specific but non-exhaustive reasons particularised above, so again, not quite clear what reasons they intend to allege but haven't yet given, which is how I read specific but not exhaustive. The claimant failed, and then there's just a general allegation to act in breach of the duty of good faith, i.e. an allegation of bad faith. And again, we asked, does this just refer to what you've alleged previously? And the answer comes back is, we won't tell you. And the same point, Your Honour, can effectively be made if Your Honour turns over the page to page 33. The first two particulars of deception, by deceiving the defendant into believing the claimant would take over fully the management and maintenance of the school's plant and machinery, by concealing its defective performance. Again, we were asked, does this refer back, or is there some other allegation here? They won't say. At various times, it's been a little unclear from the evidence whether, in relation to these two paragraphs, what was said was, all we're alleging is that you breached your contract. But I don't quite understand that, because this is the tort plea. These two paragraphs, they're the plea under Article 282 and Article 285. It's not the plea in relation to the contract. But they could clarify all of this if they answered our RFI. So there are some very serious allegations that are being made. As I said, they're not properly pleaded. We're not in a position where we can investigate. In my submission, this case is not yet ready for a CMC, because I can't say how many witnesses I'd want to call, what disclosure might look like, what expert evidence I might want to call, until the pleadings are sorted. And although my learned friend in his skeleton seems to suggest that the court should somehow be circumspect to an RFI application made before the CMC, in my submission, that's precisely when it should be made. That's why it appears as Part 19 immediately after the pleadings, because we need to clarify the scope of the pleaded case. So unless I can assist Your Honour further, that's all I propose to say at the moment.
Yes, well, that's helpful. Thank you very much. Mr. C, can you assume you're still there, even though
I'm here, Your Honour. Here I am.
And do you have any difficulty hearing any of that?
No, I was perfectly clear. I thank my learned friend for the clarity of his submissions and the airwaves for permitting me to hear them. So,
what do you want to say?
Well, I think the first point that I'd like to make, Your Honour, is that, as so often within this particular international jurisdiction, we need to consider certain cultural differences. There's the cultural difference between UAE law and English law, which I will come back to. And of course, Your Honour will be well aware that the rules of the Dubai court, or the IFC courts, the RDC, were developed by English barristers and in fact from Mr. Watson's chambers, I believe, and who were inspired to no small degree by the CPR. There's also another cultural difference and question mark which arises, I think, in terms of the CPR approach, which has now been embodied in the RDC. And it really is this question as to what purpose pleadings serve and as to what the practice really should be in terms of length, in terms of their weight and detail within proceedings. It's perhaps helpful just to consider the fact that RDC 17.47, which is at page 835 of the bundle, provides that wherever a statement of case is going to exceed 25 pages in length, that there needs to be a summary provided. Now, my learned friend has said that the pleadings that we've provided particularize insufficiently the case which is being put. The defendant and Part 21 claimant does not accept that, as you'll have seen, Your Honour, from our skeleton argument. But in addition to that, what we say is that my learned friend protests much that they have been unable to answer the case which has been put in defence and counterclaim by my clients. But the reality is that they themselves were able to serve a quite detailed reply of nearly 25 pages in response to the 25-page pleading which we put in. And I will go to that document a little later. One of the concerns that I have, and again, I'm sure that Your Honour has already read our skeleton argument in respect of interrogatories, etc., is that really what my learned friend is describing is a desire to administer interrogatories in respect of the case which is put by my clients. I'll come on to deal.
I read that in your skeleton. I'll need some persuading of that if you want to press that.
Well, Your Honour, the point is that in respect of the types of request for further information that have been made, those need to be necessary in order to understand the claim. What I hope to demonstrate, Your Honour, is that one can see from the reply and defence to counterclaim which has been entered that it is very clear that my learned friend has been able to prepare his case and answer the counterclaim stated by my clients. In respect of the cultural difference which I was discussing concerning the CPR and RDC as opposed to the old rules of the Supreme Court, for example, in England, the practice clearly today is one which expects that there will be some economy of procedure and proportionality in terms of what is permitted to be asked, etc., and what is required to be answered, especially at a request for further information stage. Now, the counterclaim which we've entered along with the defence is a detailed pleading, and I will go there shortly. But as an overarching point, the question really is whether my learned friend can fall within the requirements of the test for a request for further information. And those requirements, just bear with me for one moment, those requirements are set out clearly in the skeleton argument which we've put in. At paragraph 31, we've said that the fact that
So paragraph 31
of the skeleton, yes. What we said there was that the argument that our pleading does not allow the applicant to know the case it has to meet is somewhat disingenuous, because by the applicant's own admission, the respondent's pleading contained a substantial volume of material, including various factual assertions and lengthy factual exhibits. and they filed a detailed reply and defence to counterclaim extended to some 24 pages. So the detail which they have been able to go into in their reply, and I'll come back to that in a moment when addressing particular requests which are made, Your Honour, demonstrates clearly that they cannot show what they need to in order to satisfy the test at 19.6, because they can't demonstrate that they were unable to either understand the case that they have to meet or unable to prepare its own case. And that is a reason why we say that this application must fail, in addition to the fact that the requests which are made, which number 32 in total, although subdivided into 9 different categories, are clearly not requests which are reasonably necessary and proportionate in order to enable them to understand the case which has been put. I'll come on to the UAE law later because it is very important in terms of this question of direct harm and the lack of any requirement of intent, which relates to the requirement at RDC 17.43, which we have said or suggested applies to common law claims in respect of torts of requiring intention as a matter of English law or DIFC law to the extent it follows English law, but not, Your Honour, we say, as a matter of UAE law. Now, in respect of the commercial reality here, perhaps I can take Your Honour to the very first pages of the defence and counterclaim and additional claim which we've entered. It starts at page 12 of the bundle. Yeah. But I'm sure that Your Honour has picked up very clearly when reading that Chicago LLC entered into a construction contract to build the school for my client, Kent College. Now, during the course of that construction contract, Chicago LLC became also the maintenance services provider. Mm-hmm. And so both the contractor building the school and the maintenance services provider was Chicago LLC. What then happened was that Chicago requested the ability to novate, and again, I'll go to the pleading in a moment in respect of the language used, but it requested the ability to novate the contract to another company, which it was represented to my client, fell within the group or was an affiliate of Chicago. Now, the reality is that Chicago is the predecessor maintenance service provider, but also the contractor. We don't know the details, as you might expect, Your Honour, of whatever sale or transfer there may have been in order for Chicago's business and personnel, and we're told there's some 650 of them, to have moved to Infracare. If I could take Your Honour to paragraph 13.2 of the defence, which is at page 16.
Yeah.
There you'll see, and this is paragraph 13.2.
Yeah.
When Chicago novated the maintenance agreement to Infracare, effectively the same personnel continued to be the personnel who were delegated now by Infracare post-novation to perform the services. Now, I want to compare that, if I may, with the reply to that pleaded paragraph. And the reply begins at page 230 of the bundle, Your Honour. At page 232 and paragraph 8 of the reply, it is said that, or a reply is made in respect of the last sentence.
Stop. Page what? Sorry, what?
Page 232, Your Honour, of the bundle.
232 is, oh yes, okay.
that's a part of the reply pleading, and there, Your Honour will see that at paragraph 8, provider Chicago LLC apparently transfers the claimant and purported to continue to provide maintenance services to Kent College, now acting on behalf of the defendant. Of the claimant, I beg your pardon. And so you'll see that there is no clear denial there of the fact that there were the same personnel operating. We don't know what the details of the sale or transfer of business were, but it is reasonable to assume, and certainly it was the expectation of my client, that albeit that it was no longer the continuing construction contractor that was now going to be providing maintenance services, that the party described to us as an affiliate to whom it was novating would be able to continue to provide those services and would have information sufficient to do so, because we're talking about something relatively complex, as you will have seen from the particulars of breach of contract which we have pleaded concerning the failure to maintain certain systems within the school, which my learned friend's taken you to, and which I will return to a little later. And so there's no specific answer to the allegation. I then would turn back to the defence and counterclaim at paragraph 16.1, where my client has averred that in or about August 2018, Chicago LLC asked Kent College to sign a short document entitled Deed of Novation Agreement, and it was represented to Kent College that this change was merely a change of name on the part of Chicago LLC to become the claimant Infracare due to a corporate reorganization of the Chicago LLC group and segregation of construction and maintenance services. Now, when one turns to the reply and paragraph 10 thereof, I beg your pardon, yes, paragraph 10 thereof, in relation to...
Sorry, hold on, what page?
I beg your pardon, it's to 232, again, the same page that you were on, Your Honour.
The only difficulty is that when I'm getting them electronically, I have to put between documents.
Yes.
Page 232.
Page 232.
Yeah.
And there, when it comes to the heading, the contract,
yeah,
Your Honour will see, I think, the paragraph which you've been already directed to by my learned friend in respect of the fact that there is a denial of the fact that there is any affiliation.
Mm-hmm.
But at 11, you'll see that there is no answer provided in any specific terms in respect of the representation which was made when the, I think it's a 2-page novation agreement was produced to novate the entirety of the maintenance, the detailed maintenance services agreement. Now, what there is, however, in the reply is the perhaps customary on the page just before 231 at paragraph 2, save as admitted below, Infracare joins issue with Kent College on the defence and counterclaim, and each and every allegation contained therein is denied. But no positive case has been set out. These are bare denials. Now, coming on to the request, which I'm going to look at in a little detail, if I may, the overarching impression that the request for further information creates is that the defendant, or the defendant to counterclaim rather, and claimant, Infracare, is seeking to jump the gun, Your Honour, because the reality here is that what would follow in the ordinary course of events is a disclosure process, now, of course, labelled document production, under the RDC. That is something which would be administered following the directions given at a CMC. But one would have, in the normal course of events, that disclosure process. Then one would have an exchange of witness statements, often with an ability to reply also. What my learned friend says about his solicitor's difficulty in terms of dealing with their client as to who might have said what to whom at any one point, or the documents that they might have in respect of their actions, because we have to remember that Chicago was the construction contractor and maintenance cleaning services provider, who then passed the maintenance baton to Infracare, whom Mr. Watson represents. In passing that baton, they certainly represented, and it was understood by our client, that the whole baton was being passed. Indeed, Infracare was supposed to become liable potentially for any of Chicago's former contractual breaches or failures to perform as maintenance provider. But as my learned friend said, and we're ad idem on this point, Chicago might still have tortious liability if it had engaged in any acts causing harm, whether or not those included acts of deception under UAE law, which is a very different thing, I say, to an act of deception under English law. Fraud has not been pleaded because fraud is not alleged, and I'll explain a little more about that, if I may, in due course. But if I might, Your Honour, I'm just going to take some of the requests one by one.
Yes, of course.
Requests 1 and 2, and they are explained in my learned friend's skeleton at page 485 of the bundle. They say that our statement that Infracare and Chicago are part of the Varkey group of companies or affiliates is vague. Well, Your Honour, it might seem vague, but we're not in the happy position of having all the documents, knowledge, or information which Infracare and Chicago undoubtedly possess. Presumably, when there was a sale or transfer, certain representations and warranties would have been given. Presumably, there was a data room of documents. Presumably, they know whether they are now affiliated anyway or have been affiliated.
The question is what you mean by your statement, and if you don't mean anything in particular, or if you mean they have common shareholding or overlapping shareholding, say so. That's all they say. They just want you to explain what it is you're saying.
Well, Your Honour, we don't know what the extent of the relationship is. We understand that there is potentially some common shareholding and common ownership, but we don't know what the extent of the relationship is in terms of affiliation.
Right.
That's precisely our problem. We're not able to see under the bonnet due to the paucity of publicly available information in respect to these companies as to what the precise relationship is. We know what we were told. My client knows what they were told at the time that they agreed to sign a very flimsy novation agreement in respect of a very detailed maintenance services agreement. But they don't know what the precise relationship between these companies is, and it's within Infracare's.
Sorry to interrupt you. Are we not at cross purposes here? You may not know, but you must know what it is you're alleging. If you say they're an affiliate, it's because you think that means something. If you think it means something, why can't you say what it is you mean by it? And leave aside the question of how much detail you know. You're making an allegation. If the allegation doesn't matter and you don't want to give details, what you mean by it, that's all that's being asked.
Yes, Your Honour. The position that my client's taken is that it's obviously within Infracare's ability and knowledge as to what relationship it has or not with Chicago. And that may be relevant to the types of act of concertation, not conspiracy, and I'm very careful about the words that I'm using here, because there was concertation clearly between Chicago and Infracare. There may have been consultation which was accepted by my client in terms of the novation agreement, but there were also other acts of consultation, we say, which were acts causing harm and which were unlawful as a matter of UAE law. That doesn't involve, very unlike lawful or unlawful means conspiracy under English common law, doesn't involve any requirement of intention. And so, unfortunately, what we say is that we are entitled to know what the relationship was. We accept the main allegation that they were affiliates, but as my learned friend has said, that's a term that could mean a number of different things. The question is, was there some form of relationship, some form of corporate relationship? But that's something which we're entitled to press as an allegation and to discover as a matter of disclosure and document production within these proceedings. So I do still say that it is jumping the gun to suggest that the use of a word such as affiliate is something which we should then give particulars, or further and better particulars of, at this stage, where there's going to be necessarily a process of disclosure which will follow a CMC. Request number 3, and this is at paragraph 30 of Infracare's skeleton argument at page 486 of the bundle, relates to the air conditioning system not functioning properly. Now, if I turn, Your Honour, to our list of particulars of breach of contracts at paragraph 51 of our amended defence and counterclaim at page 30 of the bundle, you will see that a fairly detailed and specific list of particulars of breach or failure to maintain certain systems, including the air conditioning systems or the HVAC systems of the school, was provided. And not only was it provided, but in order to assist Mr. Watson and his clients in being able to prepare a reply and defence to counterclaim, which they have at some length of 24 pages, we had provided, as is the growing modern practice, and I believe now the expectation also in England, certain key documents with our pleadings by way of advanced disclosure, because we thought it proper to do so.
Yeah.
And we therefore helpfully cross-referenced every single particular to the contemporaneous factual evidence that we provided by way of these, the consultancy report from Vastu, an expert in HVAC systems, which my client had obtained. And then also, of course, the Dubai court's expert report, which we have put in as contemporaneous factual evidence. I haven't taken any instructions to date in respect of whether one would advance or seek to advance that evidence as expert evidence, but I think it unnecessary to do so, because the point of the evidence is that it's contemporaneous documentary evidence that there were significant problems with the maintenance of the systems at the school. And Your Honour, I think you will have seen the details in respect of the DEWA chart and the electricity uses, etc. But the details within the defence and counterclaim pleaded, if Your Honour can imagine that in heat which reaches sometimes 47 degrees in Dubai, that an educational institution with many school children within it would be in a position where it wasn't able to properly ventilate or provide air conditioning during particularly hot months of the year, is an extremely difficult position, also from a health and safety perspective, for that school to be in. And so it was that my client took the steps that they did in respect of obtaining the Vastu report, and then also going to the Dubai courts in respect of the expert report, which has been obtained. And the reality of this case is that my client's very strong perception and feeling, which it has asked me to communicate to the court and which we've sought to plead as best we can with the knowledge we have, is that the consultation between Chicago, which was originally the construction contractor and maintenance services provider, and Infracare, to whom it then purported to transfer its business, but certainly obtained my client's consent to novation, is that my client was then left to fall between two stools, with no one providing proper maintenance services, no one ensuring that the school's HVAC, but particularly air conditioning systems, could function properly. And we've provided the best particulars that I think we should be expected to provide at this stage. So we do reject the assertion that any of the particulars of breach of contract are too vague, because they are fully backed up by contemporaneous documentary evidence, which happens to come from suitably qualified experts whom we're not putting forward as independent experts under Part 31, or haven't applied for permission to do so, as matters stand.
Well, one of the problems, I think, under this request is that in paragraph 27 you simply say the air conditioning wasn't functioning properly, and you don't there give the sort of detail that later you give in paragraph 51, and you don't say whether your complaints are confined to those matters or whether they may include other things which you haven't told anyone about.
Well, Your Honour, we're only able, my clients are only able to speak to and therefore plead to the state of facts and knowledge that they have in terms of documents. Now, they have taken the step of, as I've said, instructing the consultant Vastu and then obtaining the Dubai court's expert report. It was perfectly proper, we say, and clear to plead at 27 that the most frequently recurring complaint was that the air conditioning which the claimant and or its service provider predecessor Chicago LLC was in charge of maintaining was not functioning properly, and then to provide particulars of the failure to maintain later on at 51, which we've done in what I would have thought was a very significant level of detail, including I can see even from someone who's not a specialist in air conditioning, that particulars 13, 14, this is at page 31, 13 and 14 relate to air conditioning, 17 relates to the entirety of the HVAC system.
Yeah.
There are
yeah.
Also very clearly certain of the particulars on the first page. I believe particulars 1 through 8, in fact, all relate to air conditioning and or heating or ventilation.
But then the answer to the request surely is to say the paragraph 51, subparagraphs 1 to 8, 13, 15, etc. And that's all you're about. And then you're delimiting the case, and people know what they're talking about.
But why should it be the case that? Why should the case be delimited is a question, a rhetorical question, which I ask and which I'm going to answer at a stage where we haven't had proper disclosure from the party which has inherited and taken over the maintenance agreement, but appears not to know anything about what it was maintaining, according to my learned friend's requests.
But surely that's circular, because they only have to get disclosure of things which are an issue. And unless you put them in issue, they don't need to give a disclosure of them.
But we have precisely put in issue the malfunctioning of the system, as Your Honour's pointed out at paragraph 27. We have put that in issue.
You don't give any particulars.
Well, we do. We provide the particulars that we can following expert advice and intervention at 51, but
then
they may not be the only malfunction.
But then it's quite simple. I think there's an awful lot of fuss being made about nothing here. It's quite simple to answer it by saying the best particulars we can give at the moment are those set out in paragraph 51, paragraphs, subparagraph, whatever. We needn't have a 2-hour argument about particulars.
Well, Your Honour, if I can move, I hear what Your Honour is saying on that point, but it's important to know that each of the individual allegations which are made in 51 were addressed by Infracare in some detail in its reply, paragraphs 39 to 55, and that's at pages 242 to 249 of the bundle.
Do you want me to turn it up?
And there, yes, please, Your Honour.
242 to 249.
Yes. And so they've clearly been able to prepare and understand and make their case in reply in respect of the very reasonably detailed, we say, particulars which were given at paragraph 51 in terms of breach of contract in our amended defence and counterclaim.
Well, that rather confirms the point I was making. If you say that those are your complaints, then they answer them.
Might I move on now to? Well, I've already dealt with the fact that the VASTU report is footnoted in respect of all of the particulars of breach of contract and technical failures. And that has they've been perfectly able to answer that. If I might move on to requests 14 and 15, which dealt with at paragraph 40 of Mr. Watson's skeleton. And obviously we've provided at that same paragraph 51 of our defence and counterclaim, which we've just looked at, a long list of defects. And again, those have all been able to be dealt with at paragraphs 39 to 55 of the reply, which I've just shown you at bundle pages 242 to 249. So it's inaccurate for Infracare to say in any way that it's left in the dark, we say, at paragraph 42 of its skeleton. And moving on to requests 16, 17, 18.
Sorry, can I just interrupt again? I'm sorry for interrupting you. But if we look at that request, at 14 and 15, request 14 and 15, it's precisely the point we've just been discussing. They say, tell us anything else you're relying upon apart from what's set out in paragraph 51. Now, the short answer is nothing. Why not say so? And then it stops the argument.
Yes, sir, but the question still is whether it's necessary and proportionate, we say. But I'll come back to that perhaps after finishing with the specific requests. So in respect of the snagging lists and requests 16, 17, 18, 19, 20, 21, 22 and 23, so 16 to 23 inclusive. That's at paragraph 43 of their skeleton argument. And what I would like to do is take you, if I may, Your Honour, to paragraph 48.2 of the reply at page 248.
48.2.
Yes, at page 246 of the bundle. And there, what Your Honour sees is that Infracare admits, in fact, that snag lists were prepared under the construction contract, and it was aware of their existence. Now, quite how Infracare could have properly been performing, it was aware of their existence and therefore must reasonably be presumed to have had access to those snag lists. Indeed, it would have needed to have had access to them in order to provide maintenance services in circumstances where there were construction works and or commissioning works still proceeding at the school when Infracare came in and took over the maintenance part of services being provided to the school. So we say that requests for documents which they must have had in order to properly perform their duties, requests for information in respect to those documents made to us, are not necessarily appropriate requests. And at paragraph 45 of our defence and counterclaim, we had, and that's page 28 of the bundle, we'd clarified that we were referring to the Chicago snagging list. And so that, of course, is the same snagging list which at paragraph 48.2 of the reply, which I've just shown you, they accept that they knew, they were aware of their existence.
So what paragraph of your defence are we on?
That was 45, Your Honour, and so it's a...
Yeah, okay, I've got it.
Yes.
As I understand
yes.
the pleadings, the claimant accept there was at least one snagging list, perhaps more. You make allegations about more than one snagging list, more than one version of a snagging list, if you like. Yep. What I think they're asking for is simply for you to make clear what it is you're referring to.
But we don't know how many snagging lists there were, because precisely we say that they were concealed from us to some degree. So and that without there needing to be any fraud, is simply the fact of the matter that we weren't provided with the snagging list. That is the case.
Are you saying there are snagging lists you still? Are you saying there are snagging lists you still haven't seen?
Well, there are snagging lists which my client, I think we've pleaded the point. In fact, had only discovered recently and had not been provided with. So at paragraph 45 and 6, if we concentrate on those in our defence and counterclaim, Your Honour, at page 28 of the bundle.
Yeah.
In particular, the defendant, when searching through its records following service of his claim, has only recently become aware that the snagging list on which the DLP monitoring was based was not, as the claimant previously believed, a list prepared by DG Jones, the independent project manager appointed under the contract for the construction of the school facilities and transmitted to the additional defendant, as it ought to have been, but was in fact a list prepared directly by Chicago LLC, the parent company or affiliate of the claimant, the CMC snagging list. The Chicago LLC snagging list omitted a series of defects which were apparent to Chicago LLC as early as 2017, but which were concealed from Kent College's knowledge by Chicago, should read LLC, and all the claimants' acts of deception, and have only recently come to the defendant's knowledge because the claimant and or Chicago LLC created a later, different, truncated and incomplete snagging list, which omitted certain items not rectified. This later inaccurate and incomplete snagging list was a list used by the claimant and or Chicago LLP in its exchanges with Kent College, and was one of the means by which the claimant and or Chicago LLP concealed defects from Kent College during the DLP, and by which the claimant and or Chicago LLC concealed their defective performance of their obligations under the maintenance agreement. Now, it may be, Your Honour, as a matter of UAE law, and we'll go there shortly, that the concealing bears no trace of dishonesty or fraud. It may have been a question of gross incompetence. We don't know. But UAE law does not require intent to be demonstrated in respect of any act, even of concealment, which might be deceptive. And we will go back to the passages which Mr. Watson showed you previously. And we'll do that perhaps just after I deal with requests 6 to 13 and 24 to 32, So 6 to 13 are at bundle 295 to 6.
Just before we go there,
Yes.
the questions you've been asked about these paragraphs 45 and 46 are really, as I read them, requests for you to identify what documents you're talking about and, where it matters, who you say compiled them, prepared them, and who is aware of the alleged defects, if anyone. I'm not quite sure what the problem is.
Well, it's clear from the pleading that we know that Chicago prepared these documents, or this is our understanding from the documents we've seen. But we don't. Why is it the case that as the party pleading, one should be expected to plead more than one knows? The fact one can ask many questions, but are they necessary or proportionate at this stage?
Hang on a second. You must know what documents you're talking about when you refer to the Chicago LLC snagging list.
Yes. My clients know which documents that they are talking about, which they've located only recently. Correct. Yes. All right.
That's what.
But they don't
asked what document it is. If you look at request 20, they want you to identify what document you're referring to when you say a later, different, truncated, and incomplete snagging list. Now, your clients must have in mind a particular document.
Yes,
why
but
why not answer the question? Sorry, I'm losing.
Yes, I'm sorry. I lost connection slightly as well, Your Honour. I think you said your client must have the document.
No, so your client presumably has a document which it refers to as, quotes, a later, different, truncated, and incomplete snagging list. And all, as I understand this question to be, is just so to avoid any doubt and misunderstanding, what is the document you're referring to? It seems on the face of it a reasonable question which could be answered either by producing the document or describe it in such a way that is unambiguous.
But then aren't we taking the cart before the horse, or giving the pleadings an importance which they're not properly to be accorded within the process of these courts, or the procedure of these courts now? Because the document production and disclosure process is supposed to deal with the provision of documents, for example. So asking a question about a document, which of course must be produced by way of standard disclosure or any other form of disclosure which is going to be ordered if a different or alternative form of document production is ordered. Is that necessary or proportionate at this stage? It depends upon what the view one takes of the purpose of the rules is, and the more streamlined procedures that I believe that the court has been trying to adopt. Because my slight concern is that we've received a very lengthy and very detailed request for further information from Infracare. We've received now a largely duplicative request for information from a party that doesn't want to admit it's an affiliate or concerting in any way, whether now or previously, perhaps with Infracare, and that's Chicago, which formerly, of course, was the operator under the maintenance contract. And we're in a position where there's an application where, frankly, I am concerned, my client is concerned, that these requests are being used to in a manner which is disproportionate to aggravate the costs which are incurred, to aggravate the expenditure of resource which my client has to make in order to get to the truth of the matter in terms of why the maintenance services weren't performed properly and how it was that Infracare and Chicago concerted in order to not perform those services or omit to perform them.
Yeah.
And there's a reasonable concern, I say, on the part of my client that these RFIs are being used as a tool of oppression procedurally, because they are not warranted for the type of matter that this is. Also, proportionality must have to do with the size and value of claim. The reason why my client is strongly defending and counterclaiming and making an additional claim is because their school wasn't maintained properly, and there is contemporaneous documentary evidence from a properly qualified person's expert in the field, which demonstrates that was the case, or will demonstrate it on the balance of probabilities. And yet we find that we are now facing tanks parked on our front lawn.
Let's not get exaggerated too much. Put it another way.
I'll put it another way.
Well, you know,
it seems to not be proportionate, and to be too oppressive to be proportionate or necessary.
Okay, right.
Because document production and disclosure and the obligations which are attached to that, Your Honour, will follow. Because each party will have to be truthful and make disclosure statements in respect of the documents which they provide.
I have your submission, yeah.
And Your Honour, if I might then just go on to these requests 6 to 13 and 24 to 32, which are all in relation to these what are said to be terribly serious allegations of fraud. And I say, no, they're not allegations of fraud, bad faith and deception by Kent College. The reality, and perhaps it might be helpful if I take you to paragraphs 43, or in fact 42 and following in our skeleton argument, Your Honour. Do you want me to provide you with the bundle pagination for that, or do you have it as a separate document?
I printed it out.
Oh, very good. So if I can just refer to paragraph numbers in our skeleton, would that be sufficient?
Yeah. Give me 1 second. Yeah, paragraph number what?
So paragraph 42, it's under the heading C4, inappropriate requests apparently made in ignorance of the applicable law, UAE law.
Yeah.
And so the point here is the point that I've already adumbrated briefly earlier, which is that acts causing harm are any act, regardless of intention, if the harm is direct. There is no reason to seek to misunderstand the plain language of the pleading which we've put forward, which suggests direct action and direct harm by one and or the other of Infracare, the claimant, and Chicago, the Part 21 defendant, acting together, or indeed individually, but directly causing harm to my clients. I'll take you to the pleading and the relevant paragraph in a moment, Your Honour, if I may, because I first want to take you to the point in respect of Article 282 and RDC 17.43.
Yeah.
Now, what we say is that, and I've encountered a number of cases in this jurisdiction where this has happened, UAE law often features in cases within the jurisdiction of the DIFC courts. It is not uncommon as the substantive law, governing law of a contract, as here, or as the law applicable to any tortious acts which may have been perpetrated by one of the parties. Now, we therefore say that any reliance upon an English concept of fraud or intention required in respect of any of the torts which we have pleaded is incorrect. It is looking through a very English lens. It seems that the RFI has very much been built in respect of what are said to be allegations of fraud, but which we say are not, and what are said to be allegations of dishonesty, which we say need not be allegations of dishonesty, but do relate to the fact of someone having been deceived, the fact of my client having had documents concealed from it, such as, for example, the snagging lists which we've discussed. None of those acts, in order to constitute a tort which is actionable and for which a party may become liable under UAE law, require intention. It's very clear from Article 282 at paragraph 43 of our skeleton. Any harm done to another shall render the actor, even though not a person of discretion, liable to make good the harm. 283 provides harm may be direct or consequential. If the harm is direct, it must unconditionally be made good, and if it's consequential, there must be a wrongful or deliberate attempt, and the act must have led to the damage. Now that's where, in a case of indirect harm or indirect damage, there might be a question of intention. But we've sought to be helpful and include the 2010 Ministry of Justice commentary on the UAE Civil Code after paragraph 44 of our skeleton.
Yeah.
And it's clear, we say, that there is no intention required or required to be proven in respect of any act causing harm if the harm caused is direct. And of course, we say on the plain language of our pleading, that is obvious from our pleading, that
Right.
we're alleging direct harm. Would you like me to take you to that, to the relevant paragraphs in the pleading so that you can compare the language?
Yeah.
If we could go to our amended defence and counterclaim at page it's paragraph 54, but it's perhaps useful to begin just before that at paragraph 53. So we simply say that they engaged, the claimant, Infracare, engaged in an act causing harm to the defendant, contrary to Article 282 of the UAE Civil Code, and those acts included acts of deception contrary to 285. And
right.
we've said that they, whether acting or alone or in combination with Chicago, paragraph 54, unlawfully caused Kent College harm and or deceived Kent College, thereby causing harm as follows. And then we've used the words deceiving and concealing in respect of various details. The first was deceiving the defendant into believing that the claimant would take over fully the management and maintenance of the school's plant and machinery and systems, including the BMS and HVAC systems from Chicago, pursuant to innovation, whereas the defendant did not in fact take over or perform properly the services required under the maintenance agreement. And there are, as you will have seen, Your Honour, 5 different detailed particulars of deception. Now, perhaps we can now look at the concept. Go back to my skeleton argument, if we may, at paragraph 46, where again we've made this point about intent as a constituting element of the tort of harmful acts under UAE law will only be required by the relevant taxes, not the direct cause of the related harm, and included again an extract from Whelan and the Ministry of Justice commentary. And we say that there is no reason to suppose within the plain language that we've used in our pleading that we are alleging that there was any indirect harm or consequential loss. It's clear that we simply say that they did acts and they have caused us harm.
Yeah.
It couldn't be any less or any more direct than that. And returning to that point in respect of 17.43, the RDC 17.43, along with the rest of the RDC, have been developed along the lines of English procedural rules. They use English language, but they use English concepts as well. So there are concepts such as breach of trust, for example, which you'll see, Your Honour, within 17.43.
Yes.
Now, I appreciate, of course, the desire of the RDC and the courts is to ensure that any facts which are necessary constituting elements of a tort are pleaded. But there is no necessary constituting element of intent in respect of either the acts causing harm which we've pleaded under 282 or indeed under 285. Now, my learned friend referred in his skeleton to the authority from Budden and Leek and Jacobs' precedents and pleadings, and that's at page 516 to 521 of the bundle. And I just want to read one passage from that. And it's a passage which says, but since dishonesty is usually a matter of inference from primary facts, this involves knowing not only that he is alleged to have acted dishonestly, but also the primary facts which will be relied upon at trial to justify the inference. Now, the primary facts are very obvious from our pleading in respect of anything which has been concealed or any deception which may eventuate to demonstrate some form of dishonesty, but is not pleaded as such because we don't know or expect that, and because the UAE law or the UAE Civil Code at Article 285 doesn't expect it either. The primary facts concerning certain of the concealments which are pleaded or deceptions which are pleaded at paragraph 54 of our defence and counterclaim are the fact that payments were never made to the MEP subcontractor PowerPoint, and defects weren't remedied during the defects liability period, and we know not what was the degree of affiliation or and/or consultation between Chicago and Infracare.
But if I might interrupt you for a minute.
Yes, of course.
Take 54.1. As I understand your case, based on Article 282, it's direct loss, you say, is called, not indirect loss. And you don't need to allege any state of mind for that. No. You just allege an act or a failure. But therefore, what you're really saying in 54.1 is you could really wrap the point up by saying, picking up on the fourth line of 54.1, simply saying the claimant did not in fact take over or perform the services required on the maintenance agreement. That's your case. That's that point, isn't it?
Rather than, unfortunately, Your Honour, is not our point, because that would potentially be a simple breach of contract, and that's not the position we're in.
What is it? Tell us.
I'm sorry, the connection. I couldn't hear your.
What is the reference to deceiving the defendant into believing that stuff? What has that got to do with your case?
Well, it has to do with the fact that it was represented to us that the claimant would take over and perform the maintenance services and would deal with snagging lists and maintenance, etc. But it didn't do so. And so, as I've said, what my client found was that it fell between two stools. And in fact, there appeared to be an abdication of responsibility by Infracare in respect of what were obviously maintenance services, and a tendency to say, well, no, it's Chicago who's got to do that because they're the construction contractor. But I'm sorry, they're not the maintenance service provider anymore. And so, I beg your pardon.
But you use the word deceiving. Deceiving is an ordinary English word, and it clearly implies deliberately concealing from someone or deliberately leading them to believe something that's not true.
Well, under UAE law, I believe it has a slightly different characterization. Perhaps we should look, Your Honour, at I appreciate it's a matter of English language, but we're stuck with the English language because we couldn't put this in Arabic because we're before.
Okay, well look, then maybe this is the answer. You look at the request 26 and 27. Yeah.
Yes.
And they're asking you about statements, and then they say they want in 26.2 what you rely upon to support the allegation that the statements were made dishonestly. Now, your answer to that is we're not alleging dishonesty. That can be said in a sentence, and then that's the end of it. What's wrong with that? And then everyone knows where they stand.
Yes.
And the same with requests 28, 29, and so on. If that's your case, and I've got no reason to question that, then that's the short answer to that aspect of the request. And the 26.1 asks you for details of the statements made, but that's a different point. But in terms of the dishonestly and concealing and so on, if you simply say you're not alleging in any dishonesty, that probably would be enough. I'm not going to say what Mr. Watson would say about it, but on the face of it, that would seem to deal with the question.
Yes. Perhaps I understand that, Your Honour. Perhaps we should just look at the civil, the piece of commentary on Article 285. But I'm grateful for your indication, for the indication you've just given. And so,
where do I find
deception? I beg your pardon. It's at page 957. I think it was the last page added to the bundle subsequent to delivery of skeleton arguments. So it should be at 957. And there at the bottom, I think you were taken to the commentary at 20356 and Article 189 of the Iraqi Civil Code, and the example of someone saying that a person who was not his son was his son, which was a deception. But there may be cases of deception, we say, where there is no dishonesty involved, which I think Your Honour has already accepted that may not be our case. At the bottom of the commentary, it says, at this page 195, deception may be by word or deed. An example of the first is a false and misleading description, whereby another is induced to act. Now, if one looks at those words, they're interesting because a misleading description could be a negligent, something that we might characterize, if thinking in English language and English law, as a negligent misrepresentation, for example.
Right.
Which wouldn't necessarily have to be fraudulent.
Right.
And so made recklessly or not knowing whether it was true or false, and therefore potentially suggesting some form of dishonesty. And so a misleading description can deceive. It's something which could potentially be done through a lack of competence or through negligence.
Right. Just so I understand your submission on this, you say a negligent misrepresentation, if you like, can fall within Article 285. It doesn't have to be dishonest.
No.
What about an innocent, non-negligent representation?
Well, it's if a deception happens by word or deed, a deception can encompass, I would venture to suggest, any form of misrepresentation.
Right.
Now, and of course, it could have the quality of what we would call, in inverted commas, fraudulent misrepresentation. So the recklessness as to a representation, but it might equally be a negligent or potentially even an innocent misrepresentation.
Well, then surely what you ought to do in your pleading in answer to the request is to say, if this is the case, and I'm not tying you down to any particular case, you say, one, we're not pleading dishonesty, not alleging dishonesty. Two, we are or we are not alleging negligence, and that's a matter for you to formulate your answer. And we are or we are not alleging innocent, non-negligent deception, which still gives us a remedy under 282. 285.
285.
Yeah, but then if you make your case clear like that, and then if you say, well, we are alleging negligence, then you ought to set out the facts and matters relied on to support your case on negligence. If you're alleging dishonesty, ditto. It seems to me that would probably enable everyone to know where they're going.
Yes. Well, Your Honour, in that case, all I do is to simply again recall what I had suggested earlier, which is that if requests are going to be or parts of the RFI are going to be acceded to, that careful consideration be given to what or which of those requests are truly necessary and proportionate, in the light of needing to ensure that there is not unnecessary expenditure of time and resource by my clients, but also given the fact that there will, of course, be the instance of disclosure and or document production which will follow, as well as witness statements which will be exchanged, I imagine, both the first round and in reply.
The document production won't tell anyone whether you're alleging negligence or not.
No, I appreciate that.
Okay.
Sure.
Right. Sorry, I interrupted you. Where are we going?
I think that concludes the submissions that we wish to make.
Yes, thank you. Thank you very much. Mr. Watson, I'm not inviting a full argument, but is there anything in particular you want to come back on? In particular, I think the point I've just been discussing with Mr. Say.
Yes, Your Honour is sorry.
Okay.
Your Honour is right that the primary purpose of the request for information was to understand precisely what is being alleged, and the ordinary use of the word deceive is an allegation of dishonesty, and that's why the RFI asked, is dishonesty alleged? And if it is, give us the particulars. If my learned friend's case is that he doesn't allege dishonesty, he doesn't allege any dishonest intent, then he can say that in response, and it would clarify matters enormously. Now, if my learned friend wants to rely on Article 285, it will be my submission at trial that article only responds to dishonesty, and I won't make the submission now, but it is plain from the language of the article and the commentary that that's what it intends, and just the mere fact that it's said that it can be done by a misleading description doesn't really answer the point. But the point is, what is his case? And if he says, well, I don't want to allege any sort of dishonesty, then that's fine. The difficulty I have is that because of the way the case is pleaded, it really isn't clear to me what they are saying. And I have to say, I'm slightly baffled by what the case actually is, for instance, in relation to the snagging lists. And Your Honour explored it a bit with my learned friend. Now, there are snagging lists, but as I understand it, what is being alleged is that there is a particular snagging list somewhere, and somebody provided that snagging list to Kent College and said, these are all the defects, when that person knew that there were other defects. That, as I understand it, is leaving aside what the governing law, what the cause of action is, just what are the facts that are being alleged. That's what I understand. Now, you can dress that up how you like, but that is an allegation of wrongdoing. because what it said is that you make a statement about something when you know that that's not true. And if their case is not that, then what is it? You know, is it just that a snagging list was provided, but as a matter of fact, it was inaccurate? In which case, they don't need to make any statements about deception or anything like that. They just need to say we were provided with some snagging lists, and they need to identify which ones and when, and say the answer. I don't accept.
Can you remind me which request this is?
The snagging lists are in relation. I think they are request 16 23 to 23.
Thank you very much.
And so it said it's impressive and that this is all disproportionate. But as Your Honour has explored with my learned friend, most of these requests could be answered in a single sentence or two. There might be some that require just a little bit more, where they allege that something was said by somebody, in which case we need to know what was said and by whom and when, because that's important. But most of these requests could be answered very straightforwardly. And it's not right for my learned friend to say, oh, well, we can just wait until disclosure. And the snagging lists are a good example, because if there's a particular snagging list that they have concerns about, then Infracare will want to investigate that and give disclosure of documents relevant to the creation of that particular snagging list. But that can't happen until the snagging list that we're all talking about is identified. So it can't be right that I just wait until disclosure. I need to know what the case is now. On the first couple of requests about affiliates, I think Your Honour had got the point that the problem with that word is that it doesn't make clear what it is that is actually being alleged. And what my learned friend seems to be forgetting is that in the system of pleadings, one makes one's allegations because one can make an allegation and support it. If material emerges later that allows you to make an allegation later, then one applies for permission to amend, and one amends to introduce a new allegation. But one can't just plead it in this very vague way and not expect to have the question asked, but what did you mean by that word? And you've seen it quite a lot, Your Honour. You might envisage how a trial on these pleadings might go, because my learned friend said a lot about concertation. Again, he says not deliberate, but how can you have concertation, i.e. working together without some sort of deliberate intent? He said it was represented that this use of the word affiliate was used. I don't think there's ever been a plea about a specific representation being made on a specific date by a specific person about affiliates. And you can just see that what is happening is my learned friend has pleaded a case very vaguely, and then in oral submission ranges over a whole array of allegations. And unless he's tied down and pinned down, this trial is going to be a costly and expensive mess. And I say, Your Honour, you shouldn't be misled by the mere length of documents. I mean, the fact that I was able to plead to the other allegations in 24 pages doesn't answer whether the allegations that I'm complaining about are adequately pleaded. And many of these requests, you know, if my learned friend said, no, we are not alleging dishonesty, then many of the requests would fall away because they're all predicate on a case in dishonesty being made. So I don't accept that any of these requests aren't proportionate. In fact, it's disappointing that we're here, because my learned friend could have, I mean, as you explored with him, request number 3 about not functioning properly, if the answer to that is just see paragraph 51, he could have written that. And we wouldn't be here, we wouldn't be troubling Your Honour, and we'd probably be having the CMC. But instead, at every corner of the case, when we've asked for a bit of clarity, we've been told not entitled.
I think I have a point.
So, Your Honour, I would invite you to order that they answer all of these requests.
Yes, thank you. I think Ms. Burt is here from Curtis, representing the, what do they call, the the Part 21 defendant. I don't know whether Ms. Burt and Mr. Say you want to have any discussion about their request, or is that not strictly on the agenda for today?
Your Honour, oh, I'm sorry. I'm trying to return with camera. I beg your pardon. Your Honour, it's obviously not part of the application today. Depending upon what Your Honour's judgment and order is, of course, we will take sensible steps to discuss with Miss Burt and those whom she represents what responses, if any, may be necessary in respect of what we think is largely duplicative, but and therefore could be might order my client to provide. So we'll, of course.
That's helpful, thank you. And Ms. Burt, you concur with that approach, do you? You're not wanting to say anything on this application?
Hi, I hope you can hear me. I'm not sure. Can you hear me?
I can, but not see you.
You can't see me. Apologies for that. We had changed rooms due to the scheduling issue. Yes, we are content with the approach proposed, and will certainly discuss with Mr. Tsay how the responses could be provided.
Thank you very much. Very well, what I'm going to do is I'm going to give my decision now. I've reached a decision, and I wasn't proposing to do a written judgment unless anyone wants to take the matter further. It seems to me that the requests are largely for information about the case made against the claimant, and largely seeking clarification of what that case is. And indeed, in those circumstances, it seems to me that they are both proportional and are reasonably necessary in order to enable this action to proceed in an orderly manner, with both parties knowing what the other side's case is. And to that end, I'm proposed to make the order that the defendant provide the particulars, all the particulars requested in the claimant's request for further information, and that is, I'll make that order in terms of the draft order which has been submitted to me for consideration, which is, if you hold on a second, the draft order is on page 292, and the operative part be that the defendant provide full and complete response to the request contained in the claimant's request for further information dated 24th January 2021. Now, how long, given the nature of our discussion, Mr. Say, it seems to me that you're not being asked to dig around a massive amount of documentation. You're simply being asked to clarify your case. Would 14 days be enough, or 21 days?
I'm just considering other deadlines we have. I think that ideally we would ask for 21 days. Of course, if we can provide them earlier, we would provide them earlier, Your Honour. And what we would look to do, of course, is to consider at the same time, as I've said, the other RFI and where that may be answered in one fell swoop with this. So
that would seem a sensible use of time to avoid coming back to the same matters twice. Are you happy with 21 days, Mr. Watson?
I am. I'd envisage giving them 21 days. That takes us to the 24th of May. If that's suitable for my learned friend, that's perfectly.
Well, I'll
fine.
make an order and I'll put a date in it. The defendant provides such responses by 24th of May, if that's a day, 21 days from now.
Yes,
Happy with that, Mr. Say?
Yes, Your Honour. Yes, thank you.
Now the question of costs arises. You've both helpfully. I should say that I'll invite you to go ahead with the idea you had of coordinating responding to this request, to consider also the request by the Part 21 defendant. But you, as you said, you and Ms. Burt will have a chat about that and see where you get to. In terms of costs, both of you have provided a statement of costs, which are almost not quite to the pound, not quite to the but within a couple of thousand of each other. I was proposing, first of all, you're applying for costs, Mr. Watson. Can you resist the costs, Mr. Say?
It's difficult to resist an order entirely, but I would simply say that from the facts of the case that Your Honour has seen, I think there is a small argument to be made in respect of costs being in the case here. We are being put to or we will be engaging a significant amount of resource with our client in order to ensure that we can provide proper answers to the particulars. We've said that we will sensibly coordinate also with the Part 21 defendant in order to provide further particulars and to ensure, we hope, that these proceedings can progress smoothly and clearly towards trial. So, and of course, my client maintains that it has good claims, both in counterclaim and in its defence to the claim made by Infracare, but also as a Part 21 claim against Chicago. And I wouldn't want those to be prejudged in any way because of the difficulty that my client inevitably faces in terms of having all information and documents which demonstrate precisely how it was left to fall, as I've said, between two stools and not to have anyone effectively providing maintenance services to its school. So that's all I'll say on the matter.
Well, any order I make for costs of this application is not influenced at all by a view of the merits of the case, which I can't possibly test at this stage. But it seems to me that, if I can say with respect, I think the suggestion that would be a massive burden in answering this request is a little bit misplaced. Most of it is clarifying the case that is being made by your clients. So on the question, I'm proposed to make an order for costs in the claimant's favour, but of this application. In terms of the statement of costs, I've been asked to assess it now.
Your Honour, sorry, just before Your Honour does that, I don't know if Your Honour received, there was an updated costs schedule.
I've got one from you, which comes to 86,145.88.
Yes, there was an error on that because if Your Honour looked at, for instance, attendances at hearing, you'll see
lots of noughts. Yeah.
Because the electronic system that the court uses to collect this data had not tracked through the figures that my instructing solicitors put in. They put in 1 hour 30 for each of them. We've gone a little bit over that, but it doesn't really matter. The total amount that the revised bill came to was 88,000 dirham, which is almost bang on the nose with what Milan and Friends cost schedule is. And for your lordship's help, in case it does, that comes out at about £17,300, just to orientate your lordship into the sort of sums you're dealing with.
Mr. Say, it's almost to the dirham the same as your bill, your outline. Is there anything you want to say about the figures?
Sorry,
Is there anything you want to say about the figures, or are you content with that is a reasonable estimate?
I think that it would be impossible to say it's not a reasonable estimate given the fact that we seem to be
that's what's been the problem with these. Yeah, very well. Well, I'll make an order in the sum of 88,000 dirham, and there's order that the defendant pay within 14 days. You content with that, Mr. Say?
Yes, I will inform my client.
Yeah. So it'll be then an order in terms of the draft order submitted with those dates and amounts inserted. Thank you both very much.
Thank you. Do you need, Your Honour, do you need us to draw an order for you?
I think if I can just ask the court staff, Maitha, are you there?
Yes, Judge.
do you need the parties to prepare an order for you, or are you content to do it from the basis of the draft order and what I've said?
Yeah, so we usually ask parties to send in the draft order.
Yes, very well. If Mr. Watson, you can.
Yes, I'm very happy to do it, as I've got the soft copy of this draft, and I'll agree it with my learned friend, and then we'll lodge it hopefully by in a couple of hours or so.
Yeah, thank you very much. Thank you all very much for your attendance.
Thank you.
Thank you, Your Honour.